Hi there. Welcome back. Thanks for joining me again. I'm Marc Spindelman. I teach at The Ohio State University's Michael E. Moritz College of Law. I'm here to share with you some more of my new work on the LGBT Title VII cases presently pending before the Supreme Court. This is The Shower's Return, a serial essay on the LGBT Title VII sex discrimination cases, Part 2. As a reminder, the last talk left off with a promise of some preliminaries on the cases, and that's where I begin. The shower today. Preliminaries. Whatever their outcomes, the LGBT Title VII sex discrimination cases have once again broken new legal ground. For the first time ever, the Supreme Court has directly taken up, both in the same term and on the same day, multiple cases involving different aspects of the rights of LGBT-identified persons. Few seem to doubt that were Justice Anthony M. Kennedy still an Associate Justice on the Supreme Court, the LGBT Title VII sex discrimination cases would be decided in step with the pro-lesbian and pro-gay equality jurisprudence he authored for the court, and thus featured as cases involving concrete expressions of the high principles of equality, dignity, autonomy, and respect that his earlier decisions both announced and vindicated. Justice Kennedy's departure from the court leaves it a relatively more open question whether LGBT rights will be secured under Title VII sex discrimination law at all. 3 cases involving LGBT sex discrimination claims are pending before the Supreme Court. 2, consolidated, involve gay men, Donald Zarda, now deceased, and Geraldine Bostock, who sued former employers for sexual orientation discrimination, said to be prohibited by Title VII's sex discrimination ban. The 3rd case involves the suit by a trans woman, Amy Stevens, sadly now also deceased, against her former employer, R.G. and G.R. Harris Funeral Homes, Inc., asserting that she suffered anti-trans discrimination, barred as sex discrimination, under Title VII. These cases formally moved along 2 separate tracks at the Supreme Court. One involves whether sexuality-based discrimination is sex discrimination. The other is about whether trans-based discrimination is. On different sides of the cases and in different ways, the issue of Title VII's meaning for lesbian women, gay men, and trans people, while in some sense formally distinct, has been notably linked. This linkage surfaces in arguments about how to interpret Title VII as a statute and how to read relevant Title VII case law. But the cases are also connected rhetorically and politically. As the cases interlocked proceeded down their ostensibly separate tracks, many pro-LGBT and anti-LGBT forces have been hoping the cases would respectively stand or fall together. Vital as these interconnections are, they imply no symmetries of significance. The linkages between the cases are forged in a fashion that places a distinctively heavy premium on the trans Title VII sex discrimination case. While anti-trans discrimination has been recognized as sex discrimination under Title VII for many years, in opinions from different federal appellate jurisdictions, written and signed by conservative and liberal judges, the trans sex discrimination case before the Supreme Court is poised to be the first such case the Supreme Court will decide in the era of its own pro-LGBT rights jurisprudence. Unfortunately, oral arguments in the case demonstrated it is slated to be settled by what may be described as a trans low information court. This means the Supreme Court may be primed to think the trans sex discrimination case, lacking secure grounding in a distinctively pro-trans Supreme Court jurisprudence, involves the larger jurisprudential leap for it to make compared to the gay sex discrimination cases, despite both how easily the trans sex discrimination claim is dispatched under established Title VII rules and how much more solidly grounded it is in lower court case law than the gay sex discrimination claims, and so easier to approve in that respect. The Supreme Court may deliver pro-trans and pro-gay decisions, but not without challenge, including reservations behind a majoritarian front announcing the results. Of course, the court could keep the cases apart from one another, ruling on their issues differently, but this would generate questions of its own, including whether such a disposition would indicate the Supreme Court is in the business of picking winners and losers in a more or less openly political play to split the baby of the cases by giving both pro-LGBT and anti-LGBT forces something to coo about. Nobody ever promised Supreme Court gamecraft would be easy. Formally, the arguments in Stevens's trans sex discrimination case, captioned R.G. and G.R. Harris Funeral Homes, Inc. against Equal Employment Opportunity Commission, addressed the two certiorari questions the case involved. Is anti-trans discrimination sex discrimination under Title VII? And is anti-trans discrimination prohibited as a form of sex stereotyping under precedent tracing to Price Waterhouse against Hopkins, holding sex stereotyping to be actionable sex discrimination in the case of a non-femme and somewhat butch, cis-heterosexual, and married woman? Answering no to both questions, Harris Funeral Home's legal defense hewed a conservative jurisprudential line on the statutory interpretation question, then easily leveraged to resolve the sex stereotyping knot. Tracking similar arguments in the sexual orientation cases, the lawyer representing the funeral home at the Supreme Court, John J. Bursch of the Alliance Defending Freedom, took the position that, consistent with its original public and legal meaning, Title VII's ban on sex discrimination meant to promote women's equality to men. This group-based understanding of the statute, read in light of certain traditions for thinking about sex in 1964, figured two and only two sex classes to which Title VII sex discrimination ban could possibly refer: women and men, defined in terms of their natural or biological forms, or, as Bursch's client himself put it at one point, an immutable God-given gift. Resisting pro-trans arguments by Stevens's lawyers, led by David D. Cole of the American Civil Liberties Union, Bursch insisted that sex under Title VII has always been, and so must remain, a trans-exclusive term. The implication of this argument, of course, was that all those lower court decisions interpreting Title VII sex discrimination rule trans-inclusively were wrong and should be corrected. Without more, this effectively counts at naught stare decisis values, including the expectation and reliance interests of workers and management alike. Bursch placed his cards upon the table at the outset of his Supreme Court argument. As he did, he inaugurated a miserable procession of highly intentional misgenderings, getting trans people's pronouns wrong, that, despite their anti-trans negation and insult, the bench silently tolerated without notable correction, presumably at least in part, so as not to show any prejudice against Bursch and his client's position. Bursch began, here I quote, "Treating women and men equally under Title VII does not mean employers have to treat men as women." That was the first moment in the argument, when Bursch misgendered Stevens as a man asking to be treated as a woman, denying her the dignity of being recognized and addressed on her own terms. Bursch continued, and much of the language I'm about to use is quoted from Bursch. "The reason why Title VII does not mean employers have to treat men as women is because sex and transgender status are independent concepts. Sex and transgender status being independent concepts, anti-trans discrimination is not sex discrimination outlawed by Title VII. The end." Not incidentally, a homologous claim was advanced by the defense in the sexuality cases, where the argument amounted to saying that Title VII's sex discrimination ban does not outlaw anti-gay discrimination because sex and sexual orientation are not the same thing. More aggressive than the conservative jurisprudential argument from original public meaning is an alternative line of thinking Bursch offered, grounded not in the soil of conservative jurisprudence so much as the related wider terrain of social and/or cultural conservative political thought. unbalancing an ostensible, if limited, concession, allowing that trans people may, in certain limited cases, actually have a Title VII sex discrimination claim, the conservative and substantively anti-trans argument that Bursch developed recommends the sweeping conclusion that there ought to be no pro-trans protections under Title VII. Underwriting this position are logics that, taken seriously, indicate there should be no pro-trans legal protections under that law or any other. Looking immediately ahead, the ultimate reason Bursch offered for why this is so is bound up with what Justice Sonia Sotomayor described in arguments in Bostock and Zarda's Title VII cases as an issue that's been raging the country: bathroom usage, same-sex bathroom usage. Briefly, before detailing Bursch's remarks, Bursch's focus on same-sex bathroom usage might have been thought a doubtful legal strategy. By its own admission, Harris Funeral Homes had allowed that the restroom issue was a hypothetical issue that had nothing to do with why Amy Stevens was fired. Bursch bypassed this as a factual constraint on his argument to make a deep and vital play around what he himself referred to at one point as the restroom scenario. By the end of Bursch's oral argument, it was clear that the deep focus of the restroom scenario was less on restrooms than on the related and more culturally charged sex-segregated spaces of showers and locker rooms, specifically showers and locker rooms for and inhabited by women, understood in the terms of Bursch's traditional definition of sex. Cisgender women, in this lexicon, is redundant. They are the only type of women there are. The specter of the restroom scenario first surfaced at the Supreme Court in paper filings in the case. Mention of ladies' showers and locker rooms surfaced repeatedly in these papers. So frequently, in fact, that the regularized return of them at some point begins to give off the impression of an undue, perhaps even prurient interest in these spaces and what takes place in them. The official transcript of oral arguments shows Bursch talking about bathrooms, showers, and locker rooms even before he braves to mention the notion of original public meaning. Retrospectively, this lexical priority, reinforced in a just-in-time final return to the restroom scenario as his oral argument ends, is a powerful indication that what properly functioned here as a or the shower and locker room scene is meant to serve, or in any event functions, as the make-or-break normative touchstone for his case. These are details from near the top of Bursch's oral argument. He's just finished making his categorical point that Title VII does not require employers to treat men as women. Now, he's trying to inoculate the Supreme Court against Cole's seductions on the first certiorari question. Cole himself had just been arguing Stevens wouldn't have been fired but for the sex she was assigned at birth, which makes her firing, an adverse employment decision, unlawful Title VII sex discrimination. Against this argument, which took Bursch's conservative sex-binaristic view of sex and turned it in pro-trans directions, Bursch maintains that the Supreme Court must reject Cole's position if it is to avoid some awful, terrible, absurd, unthinkable results. Concretely, the results of Cole's pro-trans argument and their implications for cis women, as Bursch has them in mind, are so unspeakably bad and evidently so obvious that he doesn't speak them in terms. His representation of those results on and for cis women and their bodies remains purely gestural throughout. Cole's argument, Bursch says, would, and I quote, mean that a women's overnight shelter must hire a man who identifies as a woman to serve as a counselor to women who have been raped, trafficked, and abused, and also share restroom, shower, and locker room facilities with them. That is because, but for the man's sex, he would be allowed to hold that job and to use those facilities. This is Bursch's argument his first argument from the shower and locker room scene in substance and sum. Having made it, he underscores its significance for the second certiorari question on sex stereotyping. After this, Birch invokes the scene in different ways several more times, including after the midpoint of his argument, before he returns to it in order to redraw it in a fuller way as his time at the podium ends. Like the first sketch, Birch's final rendition of the shower and locker room scene is brief and gestural. Its account of the horrific thing that a pro-trans ruling would mean for cis women is unstated as such here as well. The focus of Birch's attack, however, has now subtly shifted. It's been both expanded and contracted. Expanded, it is taking on both the but-for sex and sex stereotyping claims at once. Contracted, it is spotlighting with greater precision what the operative core of this restroom scenario is. At first, Birch's remarks make it sound like he's about to talk about bathrooms generally. They conclude the same way. This may lead those who don't pay close attention to think this is just the conventional anti-trans bathroom parlay that's being discussed. Carefully sandwiched in the middle, however, is a concern involving bathrooms euphemistically, but formally not at all. Here's what Birch says, and I quote, "One other point on the restroom scenario. Gender identity is a broad concept. You could have a male employee who identifies as a woman but doesn't dress like a woman, looks like a man, showing up in the shower and the locker room, and again, the employer wouldn't be able to do anything about that because under Mr. Cole's theory, but for the fact that he was a man, he could be there. And it's stereotyping to say men cannot be in the women's bathroom." Unquote. What's to be made of this claim? How should it be read alongside Birch's earlier depiction of the shower and locker room scene? What does it, intentionally or not, say about trans women? What does it, intentionally or not, say about cis women? Does a critical understanding of these arguments reveal that Birch's defense against claims of sex discrimination was itself bound up with and engaged in sex discrimination against women, both trans and not? Some answers to these questions next time. Thanks for joining me. I look forward to seeing you soon.